This is a lecture from Open Tuition. For the free lecture notes that go with this podcast, please visit opentuition.com.
That moves on then into statutorily implied terms, and the classic area for statutorily implied terms is in the area of sale of goods, the sale of goods legislation. And it says within sale of goods legislation that a person who sells goods, whether they're in business or not, if they're selling in the course of trade, or even if they're not selling in the course of trade. Benita wants to sell me a highlight pen. She's not doing it in the course of trade. She's not doing it in the course of business. So it doesn't matter if I'm a trader or a private individual. If I'm selling goods, sale of goods legislation says I have the right to sell these goods. These goods are my goods. Or if they're not mine, I'm acting as an agent on behalf of a principal. So I'm claiming that I have the right to sell. But what if, in a contract for the sale of goods, what if I write in the implied terms from the Sale of Goods Act shall not apply to this contract? I specifically exclude the sale of goods implied terms. Specifically write it in, and I give it to the other contracting party, and they agree and they sign the contract, and we both accept that the sale of goods implied terms as to title, as to satisfactory quality, if we've written that in, and the goods are not mine, and I sell them, does he have a claim? You cannot, by contract term or notice or agreement or negotiation, you cannot exclude these terms. It says within the Act, these terms will be implied into a sale of goods contract, and they cannot be excluded. And even though we've both agreed to the exclusion, and even though I have paid him money to accept the exclusion, even though I've given him an excessive discount to agree to the exclusion of these terms, they're not excluded. They are in every contract for the sale of goods. The term as to title is in every contract for the sale of goods. The others, satisfactory quality, fitness for purpose, sale of goods by sample, sale of goods by description, these apply where goods are sold in the course of business. Where goods are sold in the course of business by a person in business, and they're being sold to an end user. They're being sold to, the bottom point tells you, there's no need to write it, the bottom bullet point says the other elements, satisfactory purpose, cannot be excluded in a consumer contract. So if I'm selling to the end user, to the ultimate consumer, then I cannot exclude these terms. If I'm selling to another person in business, then I presume you can exclude them. You can't exclude title in any circumstance, but the others you can, so long as it's reasonable. There's a case there which I've skipped over. I need to talk a little bit about title, satisfactory quality, fitness for purpose. Satisfactory quality is a relatively new expression. It used to be called merchantable quality, but it's now called satisfactory. And it is fit, therefore. So goods of satisfactory quality are fit for a purpose. They're fit for use. They are fit for our purpose. Now we can find goods which have multi-uses. You can use them for something, you can use them for a different thing. And there's a case, Brown and Crakes, there. And Brown and Crakes is a contract for 40,000 metres of a product called Hessian. And Hessian has multiple different uses. I'll tell you. It's a material. It's a material which, in its roughest quality, you can use as a wall covering. So instead of wallpaper, or instead of a product called anaglitter, you can stick hessian on it. It's an alternative to wallpaper. I remember my mother did, in a fit of madness, she bought some hessian and stuck it on our wall, and it was a royal blue, it was deep royal blue, and it was awful. But that was my mother's taste. So that was the worst quality hessian. We also have another use for poorish quality hessian, in that it can be made into sacks, into bags, which the postman will use, and when they go around and collect the letters, they shovel the letters from the bottom of the post box into this hessian bag. So it's strong material and it can carry quite a lot of weight, but it's not good quality. But that would be another use, to make mail bags, bags for collecting the mail. But top quality hessian, really good hessian, is actually made into ladies' dresses. And no self-respecting woman would be without a hessian dress in her wardrobe. This was a case about the delivery, the sale and purchase of 40,000 meters of hessian. And 40,000 meters were delivered. And then the buyer rings up and says, "What is this rubbish that you've sold me? How on earth can I make ladies' dresses out of this?" And the seller said, "I didn't know you wanted to make ladies' dresses. You didn't specify what you wanted the hessian for. You can put it on your walls or sell it to Mike's mother." It was fit for a purpose. It was of satisfactory quality if you had wanted it as wall covering. If you had wanted it as mail bag material, that was fit for the purpose. It just wasn't fit to make ladies' dresses from. But it was suitable, it was of satisfactory quality. It could be used. So there's a general principle in English law. There's a general principle, and it's a little bit of Latin, and it's nowhere in your notes. The general principle caveat emptor. It doesn't appear anywhere in your notes, and I don't know whether it appears in the textbook. Caveat emptor. And caveat emptor translates to let the buyer beware. Let the buyer beware. If you're buying goods and they have multi-different uses, it's up to you to make sure that the goods which are sold are fit for the purpose that you want them for. How do you make sure they're fit for the purpose you want them for? You tell the seller. So you say, "I want 40,000 meters of hessian because I want to make ladies' dresses." And as soon as you say that, then it's up to the seller to make sure that the goods delivered are fit for the identified purpose. It's up to the seller to make sure that the quality of the hessian is suitable for ladies' dresses. Now you can also have the situation, and it does happen, and I don't know if it's in your notes, I can't remember. It is the possibility that you don't actually have to specify what you want the goods for. It is clearly obvious what you want the goods for. And there's a case, and again I can't remember offhand if it's in your notes, a case called Frost and Aylesbury Dairies. Aylesbury is a town in, I think it's in Buckinghamshire, down near London. Aylesbury Dairies. This is a case about a man who goes to his dairy and buys a bottle of milk. He didn't say, I want to buy some milk because I want to drink it. He did not specify the purpose for which the milk was going to be used. How many things do you think you could do with a bottle of milk, other than consume it? Cleopatra would bathe in it, yeah. Cleopatra would bathe in it. That was ass's milk, that wasn't cow's milk. That was milk from a donkey. All right? I'm talking about cow's milk here. What else can you use cow's milk for? Well, I use it as a face cream. In the evening, before I go to bed, I wash in milk, and it makes my complexion smooth and... All right, I don't. I'm sorry, I was lying. There's not much you can do, is there, with milk? I mean, even if you feed it to the cat, it's still being consumed. It's still being taken by some living... Anyway, this milk was bad. And he put it on the cornflakes, and he gave the cornflakes to his wife, and she died. So he goes back to the dairy and says, remember that milk you sold me? It was not good. It was full of a disease called brucellosis. And I gave it to my wife and she died. And they said, but you didn't tell us what you were going to do with the milk. You didn't identify to us what the purpose of your purchase was. And the court said, don't be ridiculous. The only thing you can do with milk is drink it. And if it was bad, it was bad. So you don't have to specify, because sometimes it's obvious what you're going to do. And that moves me on to page 29, exclusion clauses. These are clauses written into contracts. These are clauses which are written into contracts. And the idea of an exclusion or exception or exemption, it has the three different possible titles: exclusion, exemption, exception. Exclusion is the common way. Exemption is what you possibly claimed in order that you wouldn't have to sit papers F1, 2, 3. And some of your colleagues have possibly claimed exemption from F4. Isn't that sad? That some people are not able to enjoy the benefit of 3 days' worth of English law. Don't you feel sad for them? Exclusion, exemption, exception. You may find any of those three applied to this type of clause. And the idea of an exclusion clause is to limit or negate or cancel completely. To negate is to deny or to cancel. To limit or negate liability for breach, liability for damage. And it's an attempt by one party to limit their liability in the event that things go wrong. But in order for such a clause to be effective, in order that this mitigation, this lessening of responsibility or liability, in order that it be an effective clause, it must be brought to the attention of the other party at the time the contract is entered into. You can't enter into a contract and then subsequently impose a limitation clause into the contract. It must be brought to the other people at the time the contract is entered into. And it's always illustrated by the case Ollie and Marlboro Court Hotel, which you've got in front of you. Second bullet point, page 29. Also Thornton and Shoe Lane Parking. I'll only give you the one. You can look up Thornton for yourselves. Ollie and Marlboro Court Hotel, Mr. and Mrs. Ollie, weekend away, book into the Marlboro Court Hotel, give the details of the car, give their home address, maybe even have their credit card swiped, write their name, sign the register, and then the bellboy says, I'll take you to your room, and he gets their cases, and they go up in the lift, and they get to the room. He waits for his tip, he disappears, they close the door, and they're going down for dinner. And on the way down to dinner, they get to the door of the room in the hotel, and there's a sign on the back of the door that says the hotel will not be responsible for any loss or damage to guests' property unless you deposit that property at reception so that the hotel can keep it in their safe. And they look at it. It's just a general notice. They go downstairs, have their dinner. They come back from dinner. The door is open, and Mrs. Ollie's jewellery has been stolen. They go down to the hotel, ask for the manager. The manager says, well, I'm very sorry. I'm very sorry. But if you look, you'll see that there's an exclusion clause. We will not be responsible unless you leave your jewellery at the hotel reception. And he went to court. And the court said, well, yeah, there is an exclusion clause, but it wasn't brought to their attention at the time they were registering in the hotel. You can't suddenly introduce another clause into a contract once the contract has started. So you can't rely on the exclusion clause, and therefore you are liable. I don't know if I should tell you this story. I probably will, but I probably shouldn't. I was staying in Tashkent in Uzbekistan, and I don't know why, but I left my sweater in the hotel room. I was going to go back there 2 weeks later. I was already scheduled to go back 2 weeks later. But I only realised when I got to London that I'd left my sweater. And it was a very expensive sweater. So when I got back, I looked up their address on the website for the Sheraton Hotel, and I sent them an email and said, I'm sorry, but I've left my sweater in your hotel in Tashkent. Could you contact them and make sure my sweater is safe? I'll collect it in 2 weeks' time. I got an email back about a week later saying, could you give us the address of the hotel in Tashkent? Now let me ask you this. How many Sheraton hotels do you think there are in Tashkent? How many Sheraton hotels are there in Uzbekistan? One. And they wanted the address a week after I'd contacted them. They wanted the address. So I contacted them, and eventually I went back, and 2 weeks after I first visited, and I said to the manager, I said, I left my sweater here, can I collect it? And they said, we've no sweater in here. I said, well, I did leave it. I'm notified your head office. It's a £100 sweater. What are you going to do? I want some money. And they said, well, your sweater was not found in the hotel room. Now, I know I left it in the hotel room, and it was not found. Magic, it had gone. Or maybe a cleaner had taken it, or the housekeeper had taken it. But they accepted that they were responsible because there was no exclusion clause. But they said paying you cash is difficult. Actually, it's a difficult thing for us to pay cash in terms of compensation. Maybe there's something else we could offer, something different in kind. I said, well, what do you have in mind? He said, well, you know these young ladies that sit in the bar in the evening? And I said, no, I want my money. So they were offering something different in kind in full satisfaction of the debt which they owed me, but I had to refuse. I don't know whether I should have told you that, but I have done, so it's too late. Thornton and Shoe Lane parking, you can look that up for yourselves. These exclusion clauses should be brought to the attention of the other party. Should specifically, not just at the time the contract is made, but they should specifically be brought to the attention of the other party. And again, I'll only look at one of these, Chapeltown and Barry and Thompson and LMS Railway. Chapel, well, we've come across Chapel twice before. We've come twice, we've come across chapel, spelled differently. Whiteley and Chapel, what was that area? What was Whiteley and Chapel yesterday? What was Whiteley Chapel? Who? Golden Rule, yeah, it was gold. It was the absurdity of the application of the literal rule. Now we had another one. I've got chocolate on my mind. And 5 boys. Nestle, yeah, Chapel and Nestle. And what area of law was that? Chapel and Nestle. Consideration must have a value, and sweetie wrappings have a value. Does a peppercorn have a value? Yeah, it does, doesn't it? And even though you don't like pepper and you throw away the corn, it still has a value. What's the peppercorn rent case? Thomas and Thomas, well done. But that then leads me on to asking you, we've now had 7 cases where plaintiff and defendant have the same name. 7 we've had. What was the first? Errington and Errington. The area of law. It's no good remembering the names if you can't remember the area. You're doing well with the names, considering if you go back to 9 o'clock yesterday morning and think how much you knew then. What was Errington and Errington? Do you remember? Go on, Jana. Once you've started the acts of acceptance, the offeror cannot retract or revoke that offer. And then the next one we came across was, you all work with him. Thomas and Thomas. I think that was the next one. Thomas and Thomas, and that was the peppercorn rent. Then the third one was that strange pronunciation where the W is silent. Bezic and Bezic. And what was that about? What area of law was that? Yes, it was privity. Well done. Privity of contract, where only a person who's a party to the contract can sue. Bezic and Bezic was an exception, where the legal personal representative can sue on the behalf of the dead person. Then we had the marriage cases. What was the first one? What was the Sri Lankan tea planter? Did you ever watch the Harry Potter films? Or did you ever read the Harry Potter books? Did you? Good, right. How many balls are there in a game of Quidditch? How many balls are there in a game of Quidditch? Wow. Are you not Harry Potter fans? Have you not read the books at least twice? No. There are 4 balls in a game of Quidditch. So if I say there are 4 balls in a game of Quidditch, there's your Sri Lankan tea plantation manager, Balfour. Balfour and Balfour. And then, how do you spell man? How do you spell man? M-A-N. Yeah, so you can spell man and his wife Mrs. Spellman. Silly. Any way at all, Benita. Any way at all. What was the name of that Italian footballer? Bettini. Well done. Well done. And what's the French word for push hard? What's the French way of saying push hard? Push in French is pousser. I'll say that again very carefully in case you misheard it. It is pousser. So Poussard and Spears and Pond is the case, which is the contrasting case to Bettini and Guy. So we looked at Spellman, we looked at Balfour. Then we've got another case which was decided according to the merits of the case. Merit and merit, that's another. But that one was husband and wife living apart. We had Coombe and Coombe yesterday. What was that? Promissory estoppel, that he would promise for as long as he was able, but he wasn't able. I think I've got the right case there. That might be another one, husband and wife. But Coombe and Coombe, I'm going to set up as a promissory estoppel. But you'll look that up, won't you? You'll look up Coombe and Coombe on Google tonight. You were doing some work last night, and I promised you a test this morning. Did you actually manage to... No. All right, well, tonight. All right, we'll have a test tomorrow. Merritt and Merritt, Beswick and Beswick, Spellman, Spellman, Balfour, Balfour, Errington, Errington, Thomas, Thomas. And now we got in another one here. No. Beswick, yeah, we went through Beswick. Beswick is the exception to privity of contract. Okay, I think we're up to date with those. Chapel, that we were talking about Chapeltown, I'm sorry, Chapeltown and Barry UDC. Barry is a town in South Wales. We had South Wales yesterday. Where did we have South Wales yesterday? District, it's a big district, and the town, the major town in the district has the same name as the district itself. Glamorgan. Glassbrook and Glamorgan. Well, Barry is a town in South Wales. Glamorgan is a district in South Wales. Chapeltown and Barry UDC was about a deck chair. I can draw a deck chair. Do you know what a deck chair is? Do you remember what a deck chair is? Can you say it in your language so that everyone can understand? You don't remember what a deck chair is? Okay. It's a chair that you can rent when you go to the seaside. If you go to Jurmala, I don't know whether you're available to rent them in Jurmala, but it's a chair that you can rent, and it folds down, and there's a canvas seat, and it's that structure. And this folds upwards, and this folds upwards, and it all condenses down to a flat pack chair. You recognise it. God, I'm an artist, aren't I? So that's a deck chair, and of course they're dangerous things, because if you sit down and you not fasten it properly, if your fingers are underneath here as you're sitting down, and you've not made sure that that is secure, of course the whole thing collapses, and your fingers are trapped inside it. So in order to get up, it's a natural thing, isn't it? In order to get up, you push down to get up. It's a strange thing, but the more you push, the more you crush your fingers. So and you can't move. Have you been there? Have you tried this? Well, that's what this case is about. That's what this one is about. And the man hiring the deck chair, the man who was renting it to sit on rather than the man hiring it so that somebody could sit on it, he was given a little receipt, and it said 6 pence, 6 old pennies on the ticket. It's just a little sort of cloakroom ticket type of thing. It just said 6 pence. And underneath, in very tiny writing, it said, for conditions of hire, ask at the office, ask at the little hut along the beach. But of course you don't, do you? You don't read that. Do you ever read the tram tickets? When you get on the tram, do you ever read actually what it says on the tram ticket? I try, but there again, I don't understand your language, so even though I read it, I have not a clue what it says. Nakoma Pietra, Nazionale Opera. And I don't understand what the person is saying. So you should read the ticket, and it should be brought to your attention. And when the person, the deck chair owner, gives you the ticket, he says, can I bring this to your attention? For conditions of hire, you can ask at the office. And he didn't do it. And because he didn't bring it to the attention, and it looked just like it was just a receipt for money rather than a contract, then they couldn't claim the exemption clause, the exclusion of liability clause. They wouldn't nowadays have been able to anyway, because of something which we're coming to on the next page. Nowadays, as a result of the Supply of Goods and Services Act and the Unfair Contract Terms Act, they would not now be able to limit their liability for negligence resulting in death or personal injury. If by my negligence I cause your death or your personal injury, doesn't matter how strong my exclusion clause is, I cannot limit my liability for negligence resulting in death or personal injury. And therefore this one would not be available now anyway. That was Chapeltown and Barry UDC, where a document apparently has a legal effect. Then you should make sure what the effect is before you sign the document. There's a case there. It's a strange name. It's a very strange name. I don't know anyone in the UK called Lestrange, but I think I'm right, am I not, that Lestrange was the name of the detective in Sherlock Holmes. Lestrange. I'm not going to argue with you because he's never asked it in the exam what was the name of the detective in Sherlock Holmes. That's never come up and it's not likely to. But I don't care how you remember this strange name. Growl Cobb. Very common English name, Growl Cobb. What's the German for grey? Grau. What's a loaf of bread called which is about that size? What's a male swan called? A cob. A male swan is a cob. Male gulbe is a cob. And a female gulbe is a pen. Yeah. Do you not have that in your language? Or is it just a swan is a swan is a swan? No. And who do the swans belong to in the UK? Do you know that? Who owns all the swans? The Queen does, yeah. Our swan's protected. Which other birds do we know which are protected? Oh yeah, all right, well let me get down to, give me a bramble finch chick is protected, yeah. And we know other birds as well, don't we, in English? Top of a mountain range. The partridge, yeah. Oh, aren't you wonderful?